Good evening, Bahamas. I'm Christina McNeil, and this is MB12 for Monday, March 12th, 2012, broadcasting from the Cable 12 studios on Robinson Road. In news tonight, Kerzner International President George Markantonis reveals the latest on the resort and its financial future. The Prime Minister hints at when the House of Assembly will be dissolved, convicted sex offender Andre Borbal not happy with his lawyer, and an organization forced to relocate due to roadworks. We have those stories and much more coming up tonight. Your NB12 starts right now. Thanks for joining us. An agreement between Kerzner International and its lenders is reportedly imminent. Brookfield Asset Management pulled out of the Atlantis ownership transfer deal in January of this year. However, President of Kerzner International Bahamas, George Markantonis, revealed today that something could happen within weeks. Vonique Toot reports.
It's been nearly 2 months since Brookfield Asset Management canceled its deal to take over Kerzner International's Paradise Island properties. The noise in the market has faded since then. However, President and Managing Director George Markantonis revealed today that there may be some major developments by the end of this month.
The restructuring continues to take place. I think that all of our lenders will reach agreement with also our attorneys and our financial advisors in the short term. I can't give you an exact date, but I would say it's fairly imminent. If I had been placing bets on my speculation, I would have lost every single one. I think that something would happen. I would think something would happen by the end of March, but of course, as I said, I'm not involved in those conversations, so we'll see.
Markantonis would not speculate on whether Brookfield could still take ownership of the Atlantis resort after negotiations are complete. The Canadian conglomerate canceled its offer to exchange approximately $175 million of debt for ownership of Kerzner International's Bahamian and Mexican properties, more than a month after Chairman Sir Saul Kerzner announced the proposed ownership transfer. The shocking twist came after a group of Kerzner's more senior creditors took legal action, alleging that Brookfield had negotiated a sweetheart deal that would negatively impact the interests of other lenders. Since then, questions have been raised about what would happen to the thousands of Bahamians employed by Kerzner International Bahamas. Markantonis says it took a lot of damage control, but their fears have been allayed.
And not only just our employees, a lot of people in the country had anxiety when the stories first broke out, and of course the press, to be fair, had a lot to say about it. I think once we've had the opportunity to address the issues, we've heard from the Prime Minister about how the government views the whole transaction. You've heard from us about how we see it having no impact on our operations, no impact on our capital expenditures, no impact on our marketing sales, no reduction of staff because of the transaction. I think when people heard that, they felt a lot more comfortable, and they still do. Frankly, we have a business to run. We've got 7,500 fantastic employees, and we're running a hotel that's running in the mid-90s in occupancy right now.
Fortunately, he says, stories speculating on the Atlantis resort's future have not impacted the negotiation process.
It didn't hurt the process. If anything, when those sort of stories are run, they tend to affect the people who are reading them. But as I said, we've had a very good program internally where we keep all of our staff informed. I have personally addressed our employees. We've written letters to our employees. You've heard from the government and the Prime Minister. And basically, it was another story day. I'm sure that when there's a resolution and we do reach an agreement, that will be a very big story as well. And so it should be.
No matter what's being said, Markantonis says they won't be speculating. After all, Kerzner International has properties to run. Reporting for NB12, I'm Vonique Toot.
Well, Prime Minister Hubert Ingram is putting an end to speculation that the general election may be called much later in the year than it was last time. An election date must be given within 3 months of the House of Assembly being dissolved. However, Ingram told reporters today he doesn't need that much time.
I must dissolve the House by the 22nd of May. If I don't, on the 23rd of May, the House will be automatically dissolved by itself, by operation of the Constitution. Thereafter, election must be called within 90 days, 3 months after the 22nd of May. I don't propose to take advantage of that period, the 90 days. So sometime between now and the 23rd of May, the House will be dissolved.
Under the Constitution, there must be a dissolution of Parliament 5 years after the first sitting of the House was called after the last election. The first meeting of Parliament after the May 2, 2007 election was on May 23rd. And Prime Minister Ingram is also defending his government's record on convictions, even after the Nassau Guardian today revealed that the statistics provided by Attorney General John Delaney on the number of people convicted of murder during the Free National Movement's term in office are inaccurate. In February, Delaney tabled the names of people convicted from 2002 to 2007, when the Progressive Liberal Party was in power, and compared them to the conviction record during the F&M's term from June 2007 up to February 21st of this year. According to the numbers provided by Delaney, 9 people were convicted of murder under the PLP compared to 26 under the F&M. However, the Guardian revealed today that 5 of the people included in Delaney's list should have been omitted, as their cases were either overturned in the Court of Appeal or the murder charge was downgraded to manslaughter. Ingram disagrees.
It doesn't matter whether it's overturned. If I say you are convicted and it gets overturned by the next court, you were still convicted. No, let's get that straight. If I said you were convicted, and you were in fact convicted, and you go to a higher court and it's overturned, you were still convicted. I find this unbelievable. I find it as a nitpicking exercise. If that's the basis of what you put forward the story, that's a great distortion. In fact, a political party involved in a campaign would not put forward such a thing. That's the height of propaganda.
Prime Minister Ingram added that he is pleased with the progress his government has made with the judicial system.
The PLP has a distorted ad on the television that goes every 15 minutes. Check the facts. We've now been able to cause serious cases like murder to be set down for trial within 18 months of the charge being laid in court. It's a wonderful progress we've made. Check it. That may be a good story. It may not get headline, but it's factual. Factual. Every case in 2011 has been set down for trial within 18 months of the date of the charge being laid in court. Our objective was 2 years. So we are now exceeding our objective.
And a convicted child molester will have to wait a few more months before his appeal is heard. Kerzner Robinson tells us why in this report.
The appeal hearing of convicted child molester Andre Babal came to a screeching halt this afternoon after Babal expressed to the court that he no longer wants to be represented by his court-appointed attorney. Babal, who was convicted last year for having sex with 2 male students from the 8 Mile Rock High School, is appealing his conviction and 35-year sentence, but his appearance didn't end well today. His attorney, Craig Butler, was scolded by Court of Appeal justices for filing his submissions at the last hour this past Friday when he had an entire month's adjournment to do so. But moments after Butler was allowed to outline his grounds of appeal, Babal told the court that he no longer wants Butler to represent him. Babal said Butler did not come to see him personally and sent 2 associates who only met with him for half an hour. He also said he only got to discuss 3 of 5 grounds of submissions with them. Furthermore, he said a list of additional grounds of appeal were not presented to the court. The appellant said he thought that the additional information he gave Butler would have made it easier for him, as his associates only saw him on 1 occasion. Following Babal's comments, Butler asked the court to accept the appellant's request. We spoke with the attorney outside of court.
We filed supplemental grounds of appeal. I sent some associates up to speak with Mr. Babal, and he gave us grounds that he wished to see brought before the courts. In a legal format, we brought those before the courts. Mr. Babal and I had a difference of opinion, and in those circumstances, Mr. Babal would not have confidence in me.
Butler says he feels no weight about being axed. He says his former client is entitled to a new attorney if he feels his views are not being expressed in the way that he would want them to be.
I gave him all of the information that I'd compiled. I gave him all of the documents that I had, and I hope that the other attorney will express the views as he would like them. I will not seek any form of remuneration in the matter. If Mr. Babal was not happy with my contribution, of course I should not seek to get any money from the state.
Babal will next appear in court on May 21st for mention. In the meantime, the court will have to appoint a new attorney. Reporting for NB12, I'm Kerzner Robinson.